Joining me now is senior lawyer Nalin Kohli with more insights on this. Thank you, Mr. Kohli, for speaking to NDTV. Help us understand to what extent will this landmark judgment help in ensuring probity in public life, since privileges of parliamentarians seem very wide even now.
So I think we need to look at it from the Constitution a little carefully. The Constitution is from where each law and each privilege in that sense would come. So if you look at fundamental rights, as Indian citizens, we are treated equally before law under Article 14. Now, looking at the work to be done by the legislature in a state or the parliament at the center, certain privileges were created under Article 105 for members of parliament and Article 194 for the MLAs. Now, this was conceptualized, which is called the legislative intent, but here it's the constitutional intent. It deals essentially that as a parliamentarian or an MLA, you may have certain circumstances in which you can do your work freely and fairly. But it's inconceivable that this would amount to the law of the land not applying to them in a bribery case. That was the anomaly, and the Honorable Supreme Court has, in a unanimous judgment, gone ahead and finished that anomaly.
Right. Mr. Kohli, then why, in your view, did successive governments not challenge the Narasimha Rao judgment, which in fact very clearly was judicially perverse?
So perhaps if you look at that old case, the Congress party had much to lose. And if you look at the next allegation for cash for votes, there was a cash for questions and there was a cash for votes, which was under Manmohan Singh Ji's tenure. So therefore, perhaps it was taken as a norm, which is the days of the good old Ayaram, Gayaram kind of a thing, said that since now we have been able to get an interpretation, let's stay with it. That interpretation has been corrected, and that you have had 7 judges unanimously do so is a clear message that the law of the land cannot be used in such a perverse sense that a lawmaker is given a license to break the law. And that too, for example, one who should prevent bribes from being given and taken becomes a recipient or becomes a participant in a bribe-giving exercise. It's inconceivable by the Constitution. It's inconceivable under law.
Right. Mr. Kohli, my last question to you. Some people have also pointed out that ruling parties or parties with resources can also misuse today's judgment to harass political opponents. What would be your comments?
Well, someone would have to first be involved in a bribe-taking exercise. And if the law of the land acts against them, then if that harassment is happening, it should be a welcome harassment. Can somebody say that I have a license to take a bribe or give a bribe? Certainly not. Now let's come to the second part of it. Someone who's not involved in it, how can they be harassed? As a member of parliament, they will still enjoy certain privileges that are bound to be there in their functioning. As a member of parliament under Article 105, that has not been watered down. That exists. And those privileges, that what happens within the house, within the confines of the house, the role of the speaker, all that remains exactly where it is. So I don't agree with that sort of alarmist argument that's being put forth by some.
Right. Thank you, Mr. Kohli, for speaking to NDTV. No immunity to legislators and lawmakers. This is Supreme Court's big verdict that came in today.